Ma'am, everybody is joining, ma'am.
Yes, yes, yes. Yeah.
Is the slide
Shall I wait for 5 minutes or shall I start?
Yeah, it's already been 80 members, ma'am. We can start.
Yes, yes. Okay. Happy evening to one and all virtually present here, and welcome you all for today's study circle meet on Benami transactions. So in the past few years, the government has taken various steps to end the black money dealings through various measures such as the Black Money Act, income disclosure schemes, and demonetizations and whatnot. And in this context, the Benami transactions has been making headlines in nowadays here and there. And if you see what is Benami transactions, the curbing the black money transactions and to ensure the real transactions are conducted in the name of the actual owner. And the punishment of these violations are very stringent. So it is very essential for us to understand the nitty-gritties of this Benami Transactions Act. So to help us in to understand the in-depth knowledge of this act, we have with us an eminent speaker, CA Rajesh Sanghvi from Mumbai, study circle meet. Before handing over the session to the speaker, I'll take this opportunity to briefly introduce him. CA Rajesh Sanghvi is a proprietor of R. Sanghvi and Co. Chartered Accountants practicing for the last 32 years at Bandra. His areas of practice are income tax, GST, PMLA, Benami trust, documentation, and draft, especially property-related matters, cooperative societies, trusts, and allied laws like stamp duty, FCRA, RERA, etc. So he has done his post-management courses from ICAI, MA World Trade Center, Institute of Chartered Finance Analyst of India. He is a meritorious student. He's a rank holder, and he has secured 35th All India rank in the final May 1987, and second rank All India rank in Management Accountancy from ICAI, honors in finance course of ICFAI, and honor from World Trade Center, course in Forex. He submitted his paper on dollarization. And he has given various lectures on topics like budget, FEMA, stamp duty, income tax, penalties, money laundering laws, trust, power of attorneys, black money, Benami laws, RERA, documentation, and in various seminars and conferences all over India. He has presented papers on other topics like Right to Education Act and the RTI, and he's a regular contributes on FEMA, Black Money Act, RERA in CA manual. So with this very brief introduction, now I hand over the session to our speaker, CA Rajesh Sanghvi, sir. So over to you, sir.
Yeah. Thank you so much, CA Hitaji. Thank you very much, and I welcome all the participants. Just a humble request today. From Mumbai, we are going through a spell of bad throat, and even I'm running a bad throat on antibiotics. So, I mean, just bear with my voice, though I think so I'm reasonably audible currently.
Shivani, is it audible? Is it okay?
Yes, ma'am. It's audible, ma'am.
It's audible. Okay. In case it is not audible, please tell me.
Yes.
Okay. Thank you so much, and welcome everybody. And my respects to the SIRC office bearers and the conveners of this presentation. So the topic for us today is the PBPT Act. Call it in the short form Benami Act. The long form is Prohibition of Benami Property Transactions Act, 1988. There's a little history to this. I'll take you through the history, which is slightly important. And then, of course, the recent Supreme Court judgment of Ganpati Telecom has sort of, given certain clarifications. They have not dwelt on certain things. They're saying retrospective application is not permitted. Absolutely fine. We'll go through all of that. But the major part of the thrust would be what are the kind of cases currently which have been happening in the Benami field, which is administered by the income tax department machinery itself, the JCIT, the DCITs, etc. What kind of actions they're taking. And since this is a punitive law, punitive means punishment here in this law. What is the procedures? What are the outcomes as chartered accountants? How and where and before which authority can we appear? Right up to the tribunal at New Delhi. There's only one tribunal in the country, which is at Lok Nayak Bhavan, New Delhi, where our ITT is also located. So just to understand this, and it is a beautiful area of practice, friends, for chartered accountants, company secretaries, etc. So let's see something about this. So it's an all India law, and the original act was of 1988. It was just 9 sections, and then they thought of bringing about amendments in this 1988 act. So they brought amendments in 2015. Then in 2016, there are some committees which submitted a report, and then 2016 July, this bill was approved in the Lok Sabha, and thereafter it gives the assent, the concurrence of the Honorable President, and on 1/11/2016, 1st November 2016, the notification comes into effect that the Benami Act will be applicable from 1/11/2016. And you all very well know 8/11/2016, that was a demonetization announcement. So you see the sequence, the act coming in 15 and 16, approvals and reports, etc. And in November 16 itself, the act is promulgated. Now, along with an act, normally, generally, if I can say, we have rules and the other things coming up. So in this also, the rules were also immediately announced, and they also came into force on 1/11/2016. So the act came into force on 1/11/16. The rules also came into force on 1/11/2016. Friends, wherever in an act it is mentioned, you come across a word like as may be prescribed. So somewhere it has to be prescribed. And what is that somewhere? So the somewhere is the rules. So along with the act, the rules have to be there so that the machinery provisions come into action. So rules play an important role. Now, the earlier act of 1988, a small act containing only 9 sections, the Benami Transaction Prohibition Act. This act was there, to the best of my knowledge, somewhere in 19th of May 1988. But from 1988 till 2016, when the Amendment Act came, there were no rules. For 28 years, 1988 to 2016, there were no rules. So though the 1988 Act, which is a very short act, it had issues of what is Benami transaction, it had confiscation procedures, imprisonment, etc. But the implementation was virtually not there. There were no acquisitions done, nothing. It was a piece of legislation on paper, and not one single case in 28 years from 1988 to 2016. But the act was there. So then came, in fact, that act of 1988 also was initially by way of an ordinance, and thereafter it was converted into an act. Initially, it was an ordinance. Now, a little brief history, why an amendment was brought in this act, the 1988 Act. The 1988 Act was not repealed. Repealed means cancelled, nullified. No. It was amended in 2016. So the current act is PBPT Act 1988. It's not 2016. So why did they bring an amendment after 28 years? And why didn't they bring a new piece of law? Well, the reason which I see is that they wanted the implication of this act right from 1988 by virtue of an amendment in 2016. Of course, this has now been tested by the Supreme Court and the answers are out. But still, this entire period from 2016 till 2022, we have faced this dilemma that when you see the old act, which is of 9 sections, and the new act of 72 sections, you find, good God, this whole act has changed. The definitions, the procedures, etc. Everything has changed so much. So virtually, this is a new act in a new form, in a new avatar. But no, the government said that this is an amendment, and the earlier 9 sections are amended and introduced in the form of 72 sections. Friends, now what is critical over here is the Benami Act is not a revenue generating law like income tax. It's revenue generating. GST is revenue generating. Benami, PML, that's not revenue generating. It's a punitive law. It's a punishment law. The logic is if you do a Benami transaction or like in PMLA, you do money laundering, then one, the property will be confiscated, seized. Two, there'll be penalties. Three, there's imprisonment. So it's a punitive law. You don't have to generate revenue like income tax or like GST. So I call it as a punitive law. So it's basically penal in nature. Now, Article 20 of the Constitution. Can you have retrospective amendments in a penal law? We have retrospective amendments in income tax and GST and whatever. We have seen retrospective amendments in so many revenue laws, which have faced the test of the litmus test at the Supreme Court. And we've seen cases where matters have reached the Supreme Court has decided against the department, let's say, and there comes an amendment with retrospective effect, nullifying the effect of the Supreme Court order. But anyway, the legislature in its wisdom has got these powers. But my question is, can a penal law, penalty-based law, or penalty provision be amended retrospectively? So the answer is in Article 20, which virtually says that no person will be convicted of any offense except for violation of law enforced at the time of commission of the act charged, when the offense took place. And neither can any person be subjected to a penalty greater than the penalty which would have been inflicted under the law enforced at the time when the offense took place. In short, you cannot have a penal provision leaving penalty or something from a retrospective effect. Clarifications are something else, but you can't have a penal provision with retrospective effect. That's not allowed under the Constitution, Article 20. Now, the 1988 Act was amended in 2016. Does it amount to retrospective amendment of the 1988 Act? The lawmaker said that no, this is not a retrospective amendment. They said that that time also there was confiscation in 1988. Now also there is confiscation. That time also there was imprisonment. Now also there is imprisonment. That time also there was some fine. Now also there is fine. So we are not introducing anything with retrospective effect. So though we call it amendment, it is not to be read or to be understood as retrospective effect because it was there already in the past. This was the government's stand. Albeit still in the last 28 years from 1988 till 2016, there was a single case of Benami properties being confiscated, etc. So though one may feel that, okay, the 2016 amendment was procedural in nature and not substantive, the fact remains that it was substantive in nature. Substantive se mera matlab hai, what I mean is that you're substantially changing and altering the color and configuration of the entire act. I'm once again repeating, 1988 Benami Act had 9 sections and 2016 you introduced 72 sections, a little detailed, elaborate definition sections and the procedures, etc. And you call it amendment. This had to be tested before the Supreme Court and it was tested. Now, some part of the sections of the PBPT Act 1988 as amended in 2016 were said to be from 19th May 1998. So I repeat, the Amendment Act of 2016 said, look, certain sections will be from 19th May 1988 and some sections will be applicable from 1/11/2016. So typically Section 3 to some sections came from 1988 itself. Confiscation provisions was also there, and certain sections were deemed to have come from 19th May 1988 as evident on the screen. Why not going deep into it is because of this particular judgment. Because whatever I'm going to tell you, because of this particular judgment, it is having a serious impact. The Supreme Court judgment in the case of Ganpati Dealcom. So the question that came up before the Supreme Court, I'll go into this judgment a little later, but just an introductory remark. Because friends, I know you would like to know what is the latest position as far as Benami is concerned. But as students of law, we should know a little bit of the history also where we are coming from. On 23rd of August 2022, Ganpati Dealcom was a case before the Kolkata High Court. And Kolkata High Court, like Rajasthan High Court, decided that, look, this Amendment Act is really a substantive piece of legislation. In the cloak of an amendment, you're doing retrospectivity in an act. And so this so-called Benami Act is not going to be applicable prior to, let's say, 1st November 2016. These were the observations. This was the judgment in Ganpati Dealcom and the Kolkata and Niharika case, Rajasthan High Court also. So retrospective application was not allowed. They said yes, post 1/11/2016, this law will be there completely in force. So when you're saying it is an amendment of the 1988 Act and the 9 sections are made into the 72 sections, no, it is not a procedural change, it's a substantive change, and no retrospective application because of Article 20. So the government of India goes before the Supreme Court, and they were the appellant in this case, Ganpati Dealcom. The SLP was admitted, it turned into a civil appeal. And the crux of the Supreme Court observation is they went through the 1988 Act, they went to the 2016 Amendment Act, they went through definitions, they went into procedural law versus substantive law, they went into constitutionality of the 1988 law, certain sections of the 1988 Act, 3 subsection 2, 5, etc. And the one liner that comes out of all of this is that, and now this is the law of the land, that concerned authorities, means the Benami authorities, means the DCIT or the JCIT, etc., they cannot initiate or continue criminal prosecution or confiscation proceedings for transactions, that means Benami transactions, entered into prior to 25/10/2016. So though the act was brought into effect from 1/11/2016, this is the cutoff date Supreme Court has identified, 25th October 2016. This is available SEC online. So any Benami transactions prior to this date, which date? 25th October 2016. There'll be no criminal prosecution and no confiscation proceedings for this. So a lot of appeals at the Benami Tribunal in Delhi, which pertain to transactions prior to the cutoff date, 25/10/2016, they are now being disposed of by the tribunal because of the Ganpati Dealcom Supreme Court case judgment. Sorry. We'll go a little bit into this judgment sometime later on. Let us understand the act, but because friends, as I'm telling you, it's a beautiful piece of legislation to practice in. It's a well-paying piece. Yes, it involves a little bit of traveling. Earlier, you see in the Benami structure, you have an initiating officer, adjudicating authority, tribunal, high court, Supreme Court. This is the hierarchy. So the initiating officers may be located, the field units are all over the country, Chennai, Mumbai, Kolkata, wherever. But earlier, the adjudicating authority, the next level, adjudicating authority, it's not an appellate authority, it's just an adjudicating authority, was only located at Delhi, at Sansad Marg, Parliament Street. And for adjudicating hearings, we have to travel, whether you're from Chennai, you're from Kolkata, or from wherever, you have to go to Delhi. And the orders of the adjudicating authority, the first appeal on facts or on questionable law, whatever it may be, go to the tribunal. And there is only one tribunal in India for Benami, and that is the PMLA tribunal, the FEMA tribunal, the NDPS tribunal. They are all one tribunals. And that tribunal is at Delhi, Lok Nayak Bhavan, near Khan Market. So yes, this practice in this law requires shuttling to Delhi. You have to travel Mumbai, Delhi, Chennai, Delhi. So that's a little hindrance. Adjudicating authority offices are now the SAFEMA offices, the SAFEMA adjudicating authority, which is Mumbai, Delhi, Kolkata, Madras, Chennai. It's at all these 4 metros. Okay, so now let's see what is happening. So there is corruption. We know that. Heavy taxes, yes. Compliance issues. I'm quite sure all of your chartered accountants must be heavily bogged down with compliance work. And there is a crime also happening. There's a lot of white collar crime happening. And all this leads to black money, tainted money. And that leads to money laundering. And money laundering is nothing but converting tainted money into untainted money. Today, my presentation is not on PMLA. I practice in PMLA, but converting tainted money into untainted money is money laundering, placement, layering, integration. So this happens, and in this process, Benami starts playing a role. Benami means what? In short, if I have to just make a one-liner, let me make the entire 72 sections very simple. Benami basically means I'll take it with an example centered around me. I have the money, legal, illegal, whatever it may be. I have the money and I want to buy something. It can be a motor car, it can be an FD, it can be shares, it can be house, land, whatever. So let's take an example. I want to buy a BMW car. Let's say it's costing 50 lakhs. I have the money. Let's say I have cash acquired from some illegal sources. What is my profile? I can be anything. I can be a salaried employee. I can be a government employee. I can be a businessman, whatever. But that 50 lakhs cash I have is unaccounted, let's say. Just to make it simple, I'm presenting it this way. And I tell one of my friends that, look, I'll give you 50 lakhs. You do whatever you want to do. Just can you buy a BMW car in your name, my friend's name? And I tell one thing very clearly to my friend that, look, it is bought in your name. I'm giving the money, but the car is meant for my use or my family use or whatever, immediate or in future, whatever, but it's meant for my use. Huh? So you're just a name lender. You're just a name lender. So I'm the beneficial owner. My friend is the Benamidar. The BMW car is the Benami property, and this is the Benami transaction which has happened. Maybe I've given him cash, maybe he arranged some bank loan, purchased a BMW car in his name, the car records contain his name, RCTC book of the car, whatever the RTO records are in his name, but the car is meant for me or my family, immediately or in future, etc. So this is a Benami transaction. Fictitious transactions also come into the purview of Benami transaction. So we'll go into the definition of what all is a Benami transaction. I just try to dramatize a very simple example. Similarly, I buy a lot of agricultural land in the name of my driver. He's not capable enough. I'm putting in the money, but the land is in the name of my driver. And he's only a name lender, a Benamidar. It is meant for my benefit, for my purpose. So these are all Benami transactions. Till this stage, it is simple to understand, but once we see the cases which Income Tax Department, the Benami Property Unit, the way they are developing the cases, it is becoming scary, friends. Now, does Benami clash with PMLA? So, basically, PMLA, as we understand, and which is not my presentation today, but it's a little important to understand the interplay between Benami and PMLA. It's slightly important. So I'll just give you a bird's eye view of PMLA. Many of you all would be knowing, but still, so if it is a repetition, please forgive me. You see, in PMLA, I'm trying to give a definition and I'll go slow. Violation of certain sections of about 31 laws let's call them predicate offense, give rise to proceeds of crime, which is tainted money, and those proceeds of crime through a super intelligent process of placement, clearing, integration within India, out of India, is that untainted money is made into tainted, that tainted money is made into untainted money. That process is money laundering. And to stop that process, we have a law known as prevention of money laundering, which is administered by the Enforcement Directorate. One simple example, which will make it very clear. I told you violation of certain sections of about 31 different laws, let's call them predicate offense. So out of the 30 laws, one law is, let's say, Indian Penal Code. There are a lot of sections in the Indian Penal Code. I'll just take one section, 302, murder. So if somebody is told that, okay, you have to commit a crime, you have to murder, and you'll be getting 1 crore for that. The person commits the crime, IPC is the law, section is 302, you have committed a crime under 302, that is a predicate offense. 302, committing crime, murder under IPC is a predicate offense. That has given rise to proceeds of crime, 1 crore which that person earned by committing the crime. So 1 crore is the proceeds of crime. What is the predicate offense? Section 302 of the Indian Penal Code. That was the core crime. Of course, that crime goes to the police station or whichever are the authorities. So the person committing the crime and his aides and accomplices have earned 1 crore. So is that 1 crore tainted money? Absolutely, it is tainted money. Now that person converts that 1 crore tainted into untainted money. How does he do it? There are ingenious people on this planet to do and help out in all these things. This conversion of tainted into untainted, this is money laundering. Not that murder offense. That will be checked by the police. Only this part is what? The money laundering is what ED has to check under the PMLA. Now in this money laundering, Benami plays a role. Because these people who are doing money laundering may want to make that tainted money into untainted, not in their name, but in someone else's name. That's where Benami is coming into action. The money is meant for those people who have perpetrated the crime, but they do it in others' name, Benamidar's name. So that is why PML is a separate subject, Benami is a separate subject, but they both can or may work in tandem. Okay. So this is the definition of PMLA. Frankly speaking, section 3 of PMLA, even if you understand this much of PMLA, a substantial knowledge of PMLA is done. This definition, I don't expect you all to learn by heart, but it is a very wide encompassing definition of money laundering under the PMLA Act. So, directly, indirectly, anybody indulging on, assisting, or knowingly is a party. And it is because of these kind of words that very often and unfortunately, in PMLA or even in Benami proceedings at times, professionals are also being pulled over for aiding and abetting, which in principle and fundamentally is wrong. So that was a little bit of money laundering. Money laundering can involve Benami transactions also. And Benami transactions can also be made applicable for charitable and religious trust under section 58 of the PBPT Act, or the government can exempt. We'll see this thing in a while. So now, what does section 3 say of the Benami Act? It's very simple. It says, no person shall enter into Benami transaction. Okay, that's what you call a charging section, the lifeline, the main section. So nobody will enter into a Benami transaction. Fair enough. Nobody will enter. And thereafter it went and said that, all old offenses under the Benami, old offenses, 19 May 1980 to 1/11/2016, the jail is up to 3 years. This part, which I struck off, has been held unconstitutional by the Supreme Court in Ganpati Dealcom case. So earlier in my presentation, if I would have put the sentence, now it gets deleted. Now, nobody will enter into Benami transaction after the cutoff date of 1/11/2016, because that is a date when the notification has been announced. Or else there is jail from minimum 1 year going up to 7 years, and there is a fine also of 25% of the fair market value of the Benami property. So here we have section 3 subsection 1, nobody will enter, 3 subsection 2 held non-constitutional, and 3 subsection 3 is what I just told you, just a repetition. So this is also important, section 4, that if any property is Benami and held to be Benami, then the real owner cannot file a suit on the Benamidar or initiate legal action for recovery of that property. No, that's not permitted. This is a civil procedure. That is not permitted. Now, on this particular aspect, the Supreme Court has not actually dealt upon in the Ganapati Telecom case, which means that this is in force. And if this is in force, means this is in force from 19th May 1988, which means there is a school of thought. There is a school of thought which says that, okay, prior to 25th of October 2016, there'll be no action of prosecution or confiscation of Benami property. Fair enough. But if there is Benami property and it is in the name of the Benami Dar, can the real owner actually claim that particular property? Well, as such, Section 4 is still in place, and he will not have a right to claim that. That means it is benefit of unjust enrichment to the Benamidar. Yes, there is a school of thought which subscribes to that. So over a period of time, there'll be clarity on these issues. Anyway, leaving aside all this academic purpose, we make one statement clearly. At least from 1/11/2016 onwards, when there are Benami transactions, the real owner cannot file a suit or an action against the Benamidar or any other person to claim. And the real owner cannot claim any defense also. Now, what is the definition of property under Benami? Don't think that Benami only means land, shop, residential flats, or I took an example of a BMW car. No, that's not. The definition of property is very vast. It's movable, immovable, it's tangible, it's intangible, corporeal, incorporeal. It includes any right, interest, or legal documents or instruments evidencing title. And not only this much. So tangible, intangible, let's make it simple, or any rights. And if it is capable of conversion into some other form, then the property in the converted form. And if it is sold, then money. So that becomes a Benami property. So there is a BMW car, Benami property, sold away, and I get 40 lakhs cash or bank. Then that becomes the Benami property. So Benami property means all of this, even if it is changing its color or shade. Typically draws its definition from PMLA. So Benami property means any property which is the subject matter of a Benami transaction and include proceeds. So the person sells away the property and says, look, now there is no Benami property. No. But you have the proceeds from that property. That also carries the color of a Benami property. Okay. So what is the punchline? Any property which is the subject matter of a Benami transaction will be confiscated by the government. No compensation. Simple as that. If there is a Benami property and it is proved that this is a Benami property, it will be confiscated by the central government. Okay. Now, who's a Benami Dar? I mean, the person who's just giving his name. And can the Benami Dar transfer the property back to the real owner? So, a Benami Dar cannot transfer the property back to the real owner or on his behalf to anyone. Real owner cannot have a defense, neither the Benami Dar. Surprising, but that is the way it is. 2 subsection 10. The definitions are important, that's why I'm going a little fast on this. 2 subsection 10. Who is a Benami Dar? A Benami Dar means any person, not individual, it can be an entity also, or a fictitious person in whose name the property is transferred or held. And held should not mean just a physical holding, it should be with some inherent rights. And Benami Dar includes a person who lends his name. Now, friends, how often we hear in income tax cases of illegal premium raised on shares, 10 rupee share, 990 rupees premium. The ITO says, please justify this premium. You have got premium worth 99 lakhs. Who gave you this premium? Who purchased the shares of your company? You say, Mr. XYZ. All those XYZ people. The ITO checks their returns, capacity, identity, and genuineness. You remember section 68. And then one of that X, Y, or Z suddenly says, sir, he tells the income tax officer, sir, I don't know anything. I'm a poor man. I just lent my name. Sorry. I just lent my name. Who is saying? That person who subscribed to the share capital of the company. He's admitting, I'm a name lender. And the ITO feels, wow, he has cracked the case. Records a statement under 131. Or the assessee gets a gift from somebody. ITO examines that person who was given the gift or who was given a loan. Clearly states, sir, I have not given any loan. I got the cash. I put the cash in my bank. I gave a check. I'm only a name lender. He's a Benami. Not only that, a fictitious person is also a Benami. What is a fictitious person? A fictitious person, whether individual or partnership firm or AOP, BOR, company, or whatever. A fictitious person means there is no such person. There is no such firm. There is no such company. It's only a figment of imagination. Something like this be done? Yes, people do it. People do it. They want to buy something, buy it in the name of what? Messrs. Raj Enterprises. What is Raj Enterprises? Oh, it's a partnership firm. Is there a partnership deed? Yeah, there is a partnership deed. Who are the partners? Mr. A and Mr. B. Can I see the deed? Here is a deed. This is Mr. A, this is Mr. B, and they have signed. But in reality, there is no Mr. A on this planet, and there is no Mr. B on this planet. And this partnership firm is all a sham. It's all a sham. Of course, I understand. I'm just dramatizing the situation. It is not easy nowadays because there is KYC mechanisms, how do you open bank accounts, etc. And partnership firms may not be registered with the registrar of firms. It's not necessary. It may not be registered. What I just want to say is that there can be fictitious entities. People creating fictitious PAN cards and all that. So you create a fictitious entity itself. So any fictitious person, fictitious entity, or a person who's a name lender, in whose name the property is transferred or held, all these people fall in the category of Benami Tar. A transfer, typical to 2 subsection 47 of the Income Tax Act. A transfer to subsection 29 of the Benami Act, PBPT Act 1988 means it includes, so it's an inclusive definition, sale, purchase, or any other form of transfer of right, title, possession, or lien. That means handing over possession to a person. I'm not sold. I'm not actually transferred, but I'm giving you possession. Now that possession should be de facto possession. It's not just hold this car for 2 days, or just keep this car for 2 days in your garage. That is also giving possession. No, I'm not talking of something like that. It should be a de facto possession, a possession whereby the person is actually in the substantive rights to enjoy the possession of those goods or that property or whatever it may be. That is why you can say that he is into the de facto possession, though he may not be the legal owner of those particular whatever is that property. So this is also treated as transfer. So very often to take up a defense that, oh, but he's not the owner of the property, his name is not there on the demat account or on the property documents, he is legally not the owner, he's just holding the property. So even if he's in effective possession, that can also amount to transfer. Well, let us understand the critical definition of Benami. Friends, I just want your attention to the next few slides because 2, subsection 9 is a definition section. This has A, B, C, and D. And if you know the A, B, C, D, you know the Benami Act. Procedures, okay. Anybody can understand. Procedures is not difficult. I share with you my experiences also on the procedures. But if you know A, B, C, D, and the definition, and you can catch it, it serves the purpose. Okay. So now to subsection 9, let's see the A part. This is slightly critical, little application of mind, and you'll be able to understand and master this section. And then whatever litigations are there on Benami are hinging around this, your interpretation of 29A, B, C, D. So Benami transaction is basically a transaction or an arrangement. As soon as I start with this, I have to stop. Transaction I can understand. In my arrangement, I can use a Hindi term for this. Since I'm from Mumbai, I can use a Hindi term for this. And that Hindi term will be मुंबई में ऐसा ही व्यवहार चलता है. दिस इज अ प्रैक्टिस. हम लोग ऐसे ही काम करते हैं. हम लोग का अरेंजमेंट है इंटरनली. अरे बट कुछ डॉक्यूमेंटेशन कुछ लिखा पढ़ा है नहीं, अरेंजमेंट होता है. इट्स अ स्ट्रेंज वर्ड and they've got it into the legislation. A transaction or an arrangement. So it's a uncodified system of practice. We work like this only. It's an uncodified way of working, but that is being covered. So a transaction or arrangement where a property, what is a property? Tangible, intangible, corporeal, incorporeal, etc., including proceeds, where a property is transferred or is held by a person. So transaction and an arrangement, two words. Property is transferred or held by a person. So friends, can I say that the word transaction should be read with transferred and the word arrangement should be read with held? If you say yes, sorry, I just went to the next slide, but I'll come back to the earlier slide. I'll come back to this slide. I'm repeating my point. A transaction or an arrangement where a property is transferred or is held. So two over here, two words over there. So transaction should match with, transaction should be read with transferred, means I'll read it like this. A transaction where property is transferred to a person. An arrangement where property is held by a person. Is this the way I should interpret it? Let's go to this maxim of redundant singular singulis. The term transaction will go with the word transfer and the term arrangement will go with the word held by. It's a maxim. This is the way I interpret it, and I'm open to interpretation, friends, because we continuously keep discovering. So the term arrangement is used in the company. See, words are sometimes used in company of one another. So the word transaction and arrangement, they're used in company. And so accordingly, when we apply the doctrine of constitutive resortis, it takes the color from the word transaction. In fact, all these words take color from one another. Now I'm just reading this relevant part slowly, which may help us to understand. Let's see. Let me catch it somewhere from midway. Yeah. This doctrine is a legitimate rule of construction to construe words in an act of parliament with reference to words found in immediate connection with them. Transaction, arrangement. When two or more words which are susceptible of analogous meaning are clubbed together, they are understood to be used in a cognate sense. The term arrangement also indicates some scheme, understanding, or concerted action. It means to plan, position, highlighting. What I want to say over here is that these two words, I'm coming back to the section, transaction and arrangement are in company, and the word transferred and held are in company. So we go by the 1:1. This has to be tested. This has to be tested. Based on my research, I have certain issues, but yes, it is open to discussion, friends. So if it is a transaction, I would say it is linked to the word transferred, and if it is an arrangement, it is linked to the word held. Arrangement has a very wide connotation, very, very wide connotation. Let's go back to the definition. And this definition 29A has three parts. First part, then there is an and. Second part, then there is an and. All the three parts should be there to prove that it is a Benami transaction. Sorry, let's start once again. A transaction or an arrangement where a property is transferred or held by a person. Stop. And the consideration for such property has been provided or paid. Provided or paid, not necessarily paid. He provided that consideration from some other source. Provided or paid by another person. Second part. Stop. And. So there is an and, there is no or. There is an and. And now the third part. This third part also has to be established. And what is the third part? And this particular property that we're talking about is held. We're not talking of the transfer, we're talking of held. Is held for the immediate or future benefit. Direct or indirect, or the person who's provided the consideration. So there are three parts. So first, there has to be a transaction or arrangement where the property is transferred or held by a person. Benami. So the BMW car is held by my friend. It was transferred in his name and he's holding it. It's in his building, in his garage. Consideration for such property is BMW car. The consideration for the property has been paid or provided by another person, me. So I told somebody, gave him this money and whatever. Either I paid him or I got it provided. So the consideration has been paid or provided by another person. The other person is the real owner. Real owner, that's me, let's say in this example. And now the third part, this is most critical. This part has to be fulfilled. Just transaction arrangement in his name and money provided by me. No, that's not enough. All three have to be fulfilled. And the third part is that property, that BMW car is held by the Benamidar. It's in his garage for the immediate or future benefit of myself. मुझे कल का कल I want to go for a drive. Car should be available. Or I tell him, एक काम करो, 2 महीने के लिए गाड़ी को अपना garage में रखो. Don't remove it for 2 months. After 2 months, I will start using it. Right now, just keep quiet. Immediate or future benefit. Direct or indirect of the person who is providing. So I may tell him, first I will not use it. Let my brother-in-law and others start using it. After 1 year, I will use it. I will sit in the car and use it. 6-7 महीने के लिए नहीं तो इसको भाड़े पे लगा दो ये गाड़ी को. I'm being very careful. But the fact remains that property BMW car is for the immediate or the future benefit, direct or indirect by the person who's provided the consideration. These ingredients should be there, then it is a Benami transaction. Sum and substance, transaction or arrangement, the property is transferred, held by a person, consideration provided by another person, the real owner, such that the property is meant for the benefit, direct, indirect, future, immediate of that person who's provided the consideration. If all these three are there, it is a Benami transaction. Come back to this maxim, but we've gone through it. So my interpretation is transaction or arrangement goes with transferred or held by. Now, I told you what is 29A. But if we go by such a definition of 29A or Benami, then we're going to face some problems, real life problems. I suppose in every second house, the husband buys a property in the name of his wife. Money is provided by the husband, held in the name of the wife, and it is meant for the benefit of the husband. That means 29A conditions are fulfilled. So that becomes a Benami transaction. Remember 29A. Property held in the name of Benamida, money provided by the real owner, and the property is for the benefit of the real owner. Husband provides the money, property is in the name of the wife and husband joint bhi ho sakta hai. Property is in the name of the wife, money provided by husband, and that house is meant for the husband also. So that means it is Benami. So this was thought about, and they came out with 4 exceptions. The first one, HUF, Hindu undivided family, whether the Dayabhav or the Mitakshar or whatever it may be. So the property is held by the Karta or the member of the HUF. In Karta's name or the member's name. The car is in the member's name, BMW car. And it is there for the benefit of the Karta also and other members of the family also. And the funds for that BMW car is provided out of the known sources of the HUF, not known sources of income. The word originally in the legislation was going to be known sources of income. The Institute of Chartered Accountants vigorously argued the matter and off income word nikal diya, known sources of the HF. So what is happening? HF provided the money, car bought in the name of the HF. Again, compare it with 29A. Compare it with 29A. HF provides the money, car bought in the name of the HF, sorry, the Karta or any member, and it is meant for the benefit of the HF, all members. Wow, that's 29A attracted. No, the legislation says no. This is an exception. So if the property is held in the name of the Karta or any member of the HF, and the property is for the benefit of the other members of the HF also, and the consideration has been provided out of known sources of the HF, HF has provided the money, then it is not a Benami transaction. Stop for a moment and ponder. I want all of you to put on your thinking caps of section 68. Benami is typically linked to 68, 69, 69 A, B, C, and thereafter 115 BBE. Friends, what do you mean by known sources of the HF? Known sources of an HF would mean known sources of income, or in general, known sources. There are some questions which are being asked, but I will just take them in some time, please. You remember in section 68, the IT was asking us, please give me the source of your income. He wants to know the legitimate source of the income. He's asking for the source of the income. Friends, known source and known source of income are two different things. They're not the same. So something can be from a known source, which may not be acceptable to the ITO. And he may tax it. वो बात अलग है. वो बात अलग है. But for Benami, you just have to explain that the source is, it's a known source. You cannot give an answer. HF के पास कहाँ से आया पैसा? साहब, वो बस था, आ गया. No. You have to give information about the source. How it got the money, whether it is income, whether it is loans to the HF, whether it is some division, whatever the money the HF has got. You have to have the known source. It cannot be an unknown source. That is why in assessment orders, if the word is coming up that, unknown sources of income or something like that, then it has the potential of triggering a problem as far as the Benami Act is concerned, though he is writing unknown sources of income. God forbid if the ITO writes unknown sources itself, then we have a problem and issues of Benami may be triggered. I'm not saying yes, may be triggered. So this is the first exception. If this is the case, then it is not being hit with the provisions of 29A. Second exception. Very often, a company buys a car, private limited company's expenditure. The company spend the money, but the car is bought in the name of the director, which is wrong. But why do companies do it? I think so. The tax on cars in a company name is much higher as compared to individual names, or for some reason. Or a trust wants to buy something and the trust doesn't buy it in the trust's name, it buys it in a trustee's name. Or an executor. In a will, there is an executor. So this is a fiduciary relationship, a relationship of trust. Trust is there between the director and the company. There is an element of trust between the trustee, public charitable trust or private trust, and the trustee, or between, let's say, the executor and the legal heirs, this trust, or partner and a partnership. There's an element of trust over here. So this is a fiduciary relationship. So whenever property is held by a person in a fiduciary relationship for the benefit of, let's say, the other entity with whom he's having fiduciary relationship, 29A will not be attractive. So the best example I can give you is a partner buying a property in the partner's name out of partnership funds money, and it is meant for the partnership firm, but it is bought in the name of the partner. If you see 29A, the ingredients are complete. Property bought in partner's name, funds provided by the partnership firm for the benefit of the partnership firm. 29A is attracted. Or take a director, property bought in the name of director, funds given by the company for the benefit of the company. 29A is attracted, but no. If it is a fiduciary relationship, it is excluded. But. Friends, the documentation has to be very clear. The recital of the documentation has to be very clear. The resolutions passed by the company have to be very, very clear. That mistake should not be done. So this kind of a drafting, when these documents are being done and being bought in the name of a partner or a trustee or a director, you can't go by the regular ways of drafting, because that would be done under the TOPA Act, Transfer of Property Act 1882. A skilled lawyer will be doing according to that. But if you know the Benami provision, this section will strike to you. Paisa kaun de raha hai? Firm. Lena kaun hai? Partner ke naam pe. Why in partner's name? Why in a firm's name? But a firm is a conglomeration of persons only. So then you can put it in the recitals part and take sufficient care of this so that you're not attracted, you're not hit with 29. Second exclusion. So first exclusion karta, second exclusion fiduciary relationship. Third exclusion, which we all know, property held by an individual in the name of his spouse or in the name of his child. Literally every family in India is doing it. And the consideration is provided by the known sources of the individual. So Rajesh Sanghvi purchases the property in the name of his wife. Only, let's say, only in the name of his wife. She has not contributed money. I have contributed 29A. And the property is meant for my benefit also. She may also stay, logically, of course. And it's meant for my benefit. So that means 29A is attracted. No, there is an exception. India has a system. You buy in the spouse's name. And of course, recently you must come across the judgments also of ITAT. This is just my suggestion. My experience and my suggestion is, whenever properties are being bought in joint names, whenever, and joint can be husband, wife, father, children, brothers, anyone joint, they are being bought in joint name, friends, ensure that the ratio amongst the purchasers is written in the body of the agreement. So I'm buying a property with my wife. I can be 99% owner, she can be 1% owner. I can be 99.9% owner, she can be 0.1% owner. I can be 90, she can be 10, whatever it is. Whatever it is. Try to get the ratio in the body of the agreement. It's important. Otherwise, okay, Benami may not come into action. I'm not saying Benami, but there are other acts which can always come into action. The Transfer of Property Act says that if no ratio is mentioned, it will be assumed 50-50 or 33-33-33, depending on 3 names, or 25-25-25 if there are 4 names, unless the contribution can be specifically identified. And you also have issues of 194IA, and when you sell the property, who's going to take the consideration for the sale? I mean, there are a lot of complications. Moral of the story, when you're buying property in joint names, try to ensure that the ratio is mentioned and make the payments also in that ratio. Simple as that. It's not difficult on that day. Later on, it adds to complications. So now also, buying property in the name of the spouse or the child, and child does not mean a chota bacha. It can be an adult also. After all, a 70-year-old person is also child for his father. So bought in the name of the spouse or the child, major or minor, and the consideration is paid out of known sources. Same logic. I'm not saying known sources of income, but known sources should be there. Then there is no attraction of 29A. A child means what? Child is defined under 215B of the Income Tax Act. So child means biological child. It means adopted child. It means stepchild. And it means illegitimate child also. So earlier stepchild was not included, but now it is included. So I purposely put in the case laws also. So child means all of this. So don't think that first of all a child means chota sa bachcha, 5 saal ka. No. It can be an adult, huh? And the child can be biological, adopted, stepchild, and illegitimate child. So when in the previous slide I said the property held in the name of the individual, in the name of the spouse or the child, so child can mean all of this, friends. So just for academic knowledge. So we have karta, we have fiduciary relationship, we have a husband-wife-child relationship, and the fourth and the last exclusion. Fourth and the last exclusion. That means this is not coming under 29A. Please read this very, very carefully. When a property is held by any person in the name of his brother, sister, or lineal ascendant, lineal descendant, and the person who's contributing the money, the contributor, his name appears as a joint owner with that brother or with that sister or with that lineal ascendant or with the lineal descendant. And the consideration for the property which this person has provided is out of known sources. So this known sources is common. Then 29A is not attracted. So let's see an example where 29A is attracted. Is attracted, I repeat. There is an IPO, public issue of shares. I tell my real brother. This is just an example, friends. I am trying to present something in a short span of time so that you can understand the essence and where people are committing mistakes. There's a public issue, LIC public issue, and I tell my brother, apply for shares. I'll give you the money. And once the shares are allotted, you sell them and transfer the proceeds to me. Proceeds, property. Shares, property. Brother, Benamidar. Me, real owner. Ingredients of 29 are satisfied. The property he purchased or bought in his name, held in his name, funds provided by me for the immediate or the future benefit, direct or indirect, of me, the real owner. Across the country, maybe this is being done. I know you'll argue with me that, okay, I can give a gift note to my brother. Yes. So he can apply for shares with that gift or with that loan. Yes. And once he sells the shares and he makes profit and he pays income tax on that, he can always give me a gift. No? Yes, he can always give you. So there is a question of Benami in this. I totally agree with you, friends. I'm not doubting it. I'm just trying to present a picture because this is a veil you're creating, and this veil can be pierced also. The veil can be pierced to come to the actual transaction behind the scenes. Now, I tell my brother, apply for shares of LIC, joint names, me and my brother. I'll put in the money. You apply for shares, get the shares allotted, and you can sell, and whatever has to be done with the money coming to me or whatever, that is fine. Now, is Benami attracted? What is the only difference? My name is there jointly with him. Let's read the slide once again. Property held by any person in the name of his brother or sister or lineal ascendant descendant, where the name of the brother or sister, lineal ascendant descendant, and the individual appear as joint owners in any document, in a demat statement or whatever. So it should appear as joint owners, the person who is contributing the money and the brother or sister or lineal ascendant. And the consideration is out of known sources, the same thing. That means, friends, if somebody is purchasing property in the name of Chacha, Mama, Kaka, Masi, Bua, and I don't know what all, with his funds, using them as a Benamidar, and meant for the person who's contributing the money for his immediate or future benefit, direct, indirect, 298 ka last part, then friends, Benami definition 298 is attracted. You cannot say, ये transaction तो family में किया मैंने, मेरा मामा का है, मेरा चाचा है. No. The only exclusion is brother or sister, lineal ascendant and descendant. And in that also, you have to be a joint holder. People are not doing that. They just buy the property in the name of the brother. They don't put their own name. Rajesh Sanghi is contributing the money. Property is bought in my sister's name, my brother's name, for my benefit. And with my money. Prima facie, Benami is being attracted. Then, of course, everybody may have his own arguments for this particular transaction. I'm just drawing your attention. So if at all structuring of a deal has to be done, when clients come for structuring of a deal, please remember these slides and then give proper opinions. So there are 4 exclusions. What does brother mean? Brother means having one parent in common. Step brother is not covered. There is something like a half brother also. There is something like a half brother also. Let's not get into these things. Hindu Succession Act can give you. So brother basically means having one parent in common. That is half brother is also. Step brother is not included. But step child was included in 215B in child definition. Step child was included. Step brother is not included in the definition of brother. Now friends, this slide mentioned what? Lineal ascendancy, descendancy. It mentioned that. Where does the word lineal ascendancy, descendancy come from? Section 25 and section 26 of the Indian Succession Act 1925. We have heard this word so often. Lineal ascendant, descendant. So there is something known as a lineal consanguinity and collateral consanguinity. So in a straight order, me, Rajesh Sanghvi, my father, grandfather, great-grandfather, my son, grandson, great-grandson. It's a straight line of succession, lineal ascendancy and lineal descendancy. It is descended in a direct line from others. And there are a lot of people down over here related to one another, cousin brothers, their fathers and their fathers, and they're coming from a common stock of ancestor. कहीं तो भी great grandfather was same, great grandfather के दो तीन बेटे, and then their families, and then their families, and then their families. So here down the line, you will find they are related to one another, but they are related how? By a common stock of ancestors. Are they real brothers and sisters to one another? No. You use a term for them. You know what term you use? Cousin brothers. So in Hindi, you may call that as chacha ke ladke, kaka ke ladke, you know, something like that. But they're coming in a pyramid from a common stock of ancestors. That's the term I'm using. This is not lineal ascendancy, descendancy. No. Lineal ascendancy, descendancy is in a straight line. So that word comes from section 25, not from section 26. That was only for your academic knowledge. Section 26 means common stock of ancestors is collateral consanguinity. Now, friends, sorry, lineal ascendancy. I have a question for the audience over here. It's a very debatable question. I've done a little bit research on this. Even you can do it, friends. Whenever we talk of lineal ascendancy, descendancy, we talk of me, Rajesh Sanghi, father, grandfather, great-grandfather, beta, pota, son, grandson, great-grandson. A girl, her mother, mother's mother, nani, par-nani, grand-nani, that girl's daughter, great-granddaughter, do they not form lineal ascendancy? Or let me ask another question. Am I not a lineal descendant of my mother? And my mother's mother, and nani, lineal ascendancy, and her mother. So can a lineal ascendancy descendancy line not be formed from the female part? Or is it only to be from the male part? In Hindi, we use a word. What is that? Male-centric society, Purush Pradhan Samaj. Male-centric society. Well, I found only one judgment which has recognized even the female ascendancy descendancy part also. It was the income tax case, and that's why they recognized it. It was by the Rajasthan High Court. I don't know if I have the notice, may not be there over here, but yes, it is there. But I broke open this topic only for food for thought. I'm of the view female side can also have lineal ascendancy descendancy. So this was 29A. Sum and substance of 29A property transferred or held in the name of some person, money provided by somebody else for the direct indirect benefit immediate or future. That's 29A, and 4 exclusions: karta, fiduciary, husband wife, and brother common lineal ascendant descendant. These are 4 exclusions. This is 29A. Definition of Benami. Now let's see what is 29B. B, C, D are chota, just three lines, friends. Just see this. Real small one. There's no exclusion, nothing. Just read 29B, that is Benami. Let's see what is 29B. A transaction on an arrangement. Good God. Now again the word arrangement comes over here. In respect of a property, carried out or made. So transaction carried out, arrangement made. Redundo, singular, singulus. Transaction or an arrangement of a property carried out or made in a fictitious name. So if the property is in a fictitious name, that is a Benami transaction, period. Period. How do I give you an example for this? Friends, somebody says that property was in the name of Mr. Mohan Desai. And I purchased the property from Mohan Desai. Okay. I have a sale agreement. I purchased it from Mohan Desai. And Mohan Desai's sign is there. And I made a payment. And I purchased the property from Mohan Desai. Mohan Desai is a fictitious person. How can that happen? Mohan Desai is a fictitious person. There is nobody by the name of Mohan Desai on this planet. There may be a fake Aadhaar card, cut paste. There may be a fake PAN. Property may not be registered. It's unregistered. So that's a violation of the Indian Registration Act, 1908. And I purchased it from Mohan. And I made the payment to him. I gave him a check. Whether the check is cleared from my bank account or no, I don't know. And years later, somebody asked me, I purchased from Mohan, I gave him a check. So show me a bank account where the check is cleared. I don't have that bank account. How many of us are getting inquiries from the FAIU of the DDI office asking for details for non-residents for what? 8, 10 years asking for foreign bank statements, and the non-resident is not able to bring the bank statements. I'm just presenting a picture, friends. I'm just presenting a picture. What I want to say is that there can be a fictitious partnership firm, there can be a fictitious EOP, BOI, there can be a fictitious company also. Companies change names. Mohan Enterprise Private Limited, name changed. Deepak Exports Private Limited, same company, name changed. Uranus Traders Private Limited, name changed. So what about the first name? That certificate of incorporation is still there. Somebody can have a copy originally. Of course, there is a change of name happening every time. But I take the first certificate of incorporation, I go to some small time banker and I take a photocopy of the PAN card at that time and open a new bank account, which is wrong. It will not happen that easily. I agree. But is this entity there? Actually, there's no such entity by that first name. The company has changed names. Now the company is something else. You're just trying to create a fictitious entity. People misuse names, misuse Aadhaar concepts, PAN concepts. That's why there's a lot of stuff on WhatsApp also misuse. Moral of the story is a transaction or an arrangement of a property carried out, transaction carried out, arrangement made in a fictitious name is Benami property, period. Now it's going to hit you directly in the balance sheets. You have a loan. I2 tells you, who's this loan? Sir, it is some firm or some company or some individual. Okay, call him. So not available. It's possible he may treat him as a fictitious entity, fictitious name. He may make an addition and you will pay tax. That's another thing. But PBPT Act to apply, that can be scary. That can be scary, may be scary. Let's see the C part. A transaction or an arrangement, again the word arrangement, in respect of a property, where the owner of the property is not aware of or denies knowledge of such ownership. So there is 50 acres of land in Chennai belonging to some poor time driver. The income tax department, Benami department goes to him and tells him, come here. You're the owner of 50 acres of land in Chennai. He said, क्या साहब 15,000 रुपए का नौकरी करता है 50 एकड़ कहां से खरीदेगा तुमको नहीं मालूम तुम्हारा नाम पे 50 एकड़ लैंड है नो सर दिस इज द डॉक्यूमेंट देखो तुम्हारा फोटो है तुम्हारा साइन है हाँ सर साइन है फोटो है बट I don't have knowledge of any such land, denies ownership of such knowledge or is not aware. Benami transaction. This is a classic example of how Benami transactions are taking place and where action should be taking place also. A transaction arrangement in respect to property where the owner of the property is not aware of or denies knowledge of such ownership. Oh, that can be. But now look at this example which I'm giving. There is a search under 132. The DDI team comes to the house and they question the lady of the house. Madam, आपका उम्र क्या है? 72. You are a partner in which firms? I'm not a partner in any firm. What firm? मैं तो घर पे होती हूँ दिन भर. There is no firm. What firm? अच्छा अच्छा. मैडम आपके नाम पे कितना प्रॉपर्टी किधर है क्या है? Can you tell us? नहीं मेरे को कुछ नहीं मालूम. अच्छा मैडम आपके नाम पे एक बहुत बड़ा बंगलो है इन जयपुर. नहीं मेरे को तो नहीं मालूम. I don't know. Whatever I'm telling you, friends, read it with line C. And we got a Demat account. Demat क्या होता है? That lady is not able to answer, and it is possible. It is possible. Either, she's not aware, or she denies knowledge of such ownership. It is possible. Now compare this with that driver, Chennai mein 50 acres in his land. I would say that is a real Benami transaction. But here, maybe the investments have been split in the name of the female members of the house or other members. To put this also into the category of Benami. Now friends, B, C, D, Doesn't require the three components of A. You know, A, there were three components. In someone else's name contributed by me for my benefit. BCD doesn't have that. BCD standalone, only these three lines. So I wouldn't say that this lady's case of a search will come into Benami. I wouldn't say that. But yes, I will add a word of caution. Ensure that the clients know their holdings. They may not remember the names and they may not know the credit card numbers and the demat account numbers and all that. I agree. For that matter, even I wouldn't know my demat account number or even my credit card number. But friends, general knowledge should be there. And if that is also difficult, then the lady can ideally give a power of attorney in the name of the male member so that the male member takes care of everything. And generally, what are the answers ladies give? We don't know anything. My husband takes care of everything or my son takes care of everything. That's the general answer. Okay. So that's C. And now we have D. A transaction or arrangement in respect of a property where the person providing the consideration is not traceable or is fictitious. देखो friends, दो बातें हैं. The person who's providing the consideration, he is not traceable, or that person is fictitious. Fictitious we already saw in B. Totally wrong. ऐसा कोई है ही नहीं. Fake, forged, bogus. It's a fraud. But this word is dangerous. Not traceable. So there is somebody, but he is not traceable. How many of our loan parties are very often not traceable? How many of, with all due respect, friends, ITOs, the moment they heard a Calcutta party, a Calcutta penny stock case, or a Calcutta-based share capital premium, you know, the kind of inquiry being done, party is not traceable. Not traceable. I'm not saying fictitious. It's not traceable. A transaction or arrangement in where the person providing the consideration is not traceable or is fictitious, that can fall into the category of Benami. Now, we saw 29A, 29B, 29C, 29D. Now, there is one explanation to this. This explanation is typically on power of attorneys. Friends, very often we work based on power of attorneys. And I'm quite sure all of you would be knowing what are power of attorneys. Power of attorney is an act, 1882, 4 sections ka act hai ye. We use a word very loosely nowadays. Not nowadays, since so long. Irrevocable power of attorney. Specific power of attorney, there are general powers of attorney, and so many things. And power of attorneys are drafted. So it is important to understand what do you mean by an irrevocable power of attorney, what are proprietary interests in the power of attorney, and concepts of power of attorney basis property being bought. Now, Benami transaction shall not include any transaction involving the allowing of possession of any property to be taken or retained in part performance of 53 of TOPA. If the consideration has been provided by the person to whom the possession has been allowed, stamp duty paid, contract has been registered. If this sounds too difficult, let me make it simple. This is also part of the section 2.9. I can give an example from Mumbai perspective. In Mumbai, we have a lot of slums, hutments. And you know, these hutments are bought by builders and they construct high-rise, and these hutments get a 300 square foot flat. And the law says that 300 square foot flat you cannot sell for 10 days. Now, the hutment has got some proof that he is staying in the hutment. We call it as a photo pass. Now, what people do is they buy these hutments. I mean, they buy that photo pass. It's all informal. All informal. Arrangement. Now the word comes arrangement. It's all informal. And the hutman dweller gives the lock and key of the hut to me and he goes away. But the hut can't be transferred into my name because it is not permitted by law. So arrangement wise, I am the owner of the hut. Legally, I'm not the owner. And I also take a power of attorney from that hutman dweller. Anywhere it is needed, I will use that power of attorney to represent him. And very often this power of attorney and this some document which I make with the hutman, I sell it to some second party, and the second party sells it to some third party, and third party sells it to some fourth party, and it's just sold and sold. I'm quite sure you all must be knowing the Suraj Land's judgment of Supreme Court, 2011 or 12. Beautiful judgment in the Supreme Court literally hammered such misuse of power of attorney and agreement for sale. unregistered. In fact, even wills are made. I make a will also of that hutman dweller. Tomorrow, if he dies, this hut goes to me, bequeathed to me. I have to take all I have to take all precaution. Because instead of this hut, I'm going to get a 300 square foot flat in Mumbai, which will be costing 1 crore. Right now, I bought this hut for only 20 lakhs. So friends, these dealings which are taking place are on power of attorney. If you see that particular hut, if the Benami unit comes and does an examination, ये hut किसका है? I will say it's mine. Show me your papers. If I show the papers are in the name of that hutman dweller. So I provided the consideration for buying this hut. Possession has been given to me. I have the lock and key of the hut. But who is the owner on paper of that hut? That fellow. The benefit of the hut goes to me when I get a 300 square feet flat or whatever, or tomorrow I may sell it. The benefit goes to me. Friends, here Benami is coming into action, and a few cases in Mumbai have developed. So people say, I just got a power of attorney, and based on the power of attorney, I'm managing the hut. I'm not going deep into this argument, friends. So what they did in the explanation, they came out with certain things. They said that, okay, if you have a transaction which is in the nature of 53A, part performance under Transfer of Property Act, where the consideration has been provided by a person to whom the possession has been allowed. I provided the consideration, possession allowed to me. But the ownership has not come to me. Then the power of attorney should be stamp duty paid and registered, or whatever document you are doing should be stamp duty paid and registered. Now I can't do a sale agreement because officially the laws of Maharashtra don't allow me to purchase a hut officially. So the contract cannot be registered, but I'm making a power of attorney basis which I'm doing the work. That power of attorney stamp duty should be paid and registered with the sub registrar of assurances. Notary will not do. So this way, in various metropolitan cities and all over, sometimes transactions are done basis power of attorney. One has to be very, very careful of that. Just using a power of attorney which is notarized may not serve the purpose. Friends, here I've just mentioned what is part performance under the Transfer of Property Act, but I think so I need not go into this. The slides will be there available for all of y'all. We very often use this word part performance 53A, even in the Income Tax Act. To subsection 47, definition of transfer, part performance, it's something critical. Okay, so this is important for us reading or having practical knowledge of this. So this is the example of stamp duty paid power of attorney system, which I just shared with all of you all, vis-a-vis Benami transaction, all these examples. Now friends, you remember in 2(9) B, C and D, especially in D, the person providing the consideration is not traceable or fictitious. It's Benami. So very often when you say the person is not traceable, you know what general answer anyone may give? साहब वो मर गया, वो कुछ साल पहले मर गया, तो अभी वो ट्रेसेबल नहीं है. I cannot bring him. So I just thought of bringing the section 106 of the Indian Evidence Act. 106, 107, 108 before all of you. Interesting reading. 106 has been quoted extensively by the Benami Tribunal also in number of judgments. Because 106 helps us in Benami. What is 106? Indian Evidence Act. Friends, the Benami law, PVPT Act, works on the principle of natural justice. Huh? It doesn't work on CPC, Civil Procedure Code. It works on the principle of natural justice, like our income tax also. And income tax strict rules of evidence are not applicable. Means you don't have to actually apply the Indian Evidence Act by the strict rules of evidence. Same in Benami also. It is helpful. It helps us in guiding. We can use the Indian Evidence Act in income tax proceedings also and in Benami also, but it is not based solely on this. What does section 106 of the Indian Evidence Act say? Where any fact is especially in the knowledge of any person, the burden of proving that fact is upon him. So the Benami department says this transaction is Benami. Okay. So who's going to prove it is Benami and not Benami? They are going to prove it. Because they are putting up the allegation that it is Benami. So the burden of proof is initially on him. Then, of course, it keeps shifting. The burden of proof shifting, as you already know, the rice mills case. But the initial burden of proof, heavy duty is cast upon the Benami department officers. Now, let us see an interesting section 107 and 108. If at all there is a question whether a man is alive or dead, and it is shown that within 30 years he was alive, and if somebody is saying no, no, he's dead, then the person who's saying he's dead, he has to prove that he's dead. Means it is not very easy to say कि वो मर गया साहब, मैं उसको नहीं ला सकता, वो मर गया. If the IT or the department people have knowledge of 107, they'll say, okay, if he was alive within 30 years and you're saying he's dead, you prove it is dead in accordance section 107. Supposing somebody says, नहीं मर नहीं गया, सब जिंदा है. Okay, let's see 108. Then the question is whether a man is alive or dead. This is Indian Evidence Act में लिखा है, friends. Then the question is whether a man is alive or dead, and it is proved that he has not been heard for 7 years by his near and dear ones. Immediate family ने उसको सुना ही नहीं है, मतलब 7 years से वो किधर है क्या है मालूम नहीं, गायब हो गया. The burden of proving that he is alive is on the person who claims him to be alive. So, in either situation, don't give an answer very fast that not traceable 29D, सब वो मर गया, ऐसा वो जिंदा है. No. Be very, very careful, because there are these sections of the Indian Evidence Act which may go against the person who is arguing. Friends, sham transaction is something else and Benami transactions are something else. Genuineness is important. So now we are, sorry. A transaction arrangement is property where the person providing the consideration is not traceable. This doesn't tell us how far the enforcement agencies can go, but I've already told you in the recent Ganpati Dealcom case, prior to 25/10/2016, the Benami department cannot go. That is why, friends, whenever any transaction is being done, buyer selling or whatever is being done, please do your KYC very well. Now, you're taking a loan or a gift or buying property or whatever, registration, that's why important, because registration means the person came to the sub-registrar's office, he's given his biometrics and the face in front of the sub-registrar of assurances. So we cannot say he's not fictitious and all that. Yes, it was a genuine person. So generally, even when we are doing any kind of dealings, ensure that you have the PAN or the Aadhaar or the ITR, and perhaps a joint photo with that person is helpful. And a very good way of doing things is, my personal opinion, friends, I can be wrong, ensure that for your documentation, whether it is a loan agreement, whether it is a gift deed, whether it is a purchase of property or whatever, ensure that there are 2 witnesses who know you and who will stand by you at the appropriate time. So just don't only rely on PAN and Aadhaar. Please take copy of his ITR also. Please take photograph joint with him also, and take witness or witness ka bhi KYC lena. So not traceable and fictitious ka bhi question aa gaya na, we'll have good answers to give, friends. Okay. Now what happened in demonetization? Now I'm giving examples of Benami transactions which have been caught by the Benami unit. X gave cash of 2 lakhs to be deposited in your bank account and give it back to me. Circular transaction, getting hit with Benami. X buying a car, the first example I took, with his money in the name of his cousin. I took an example of a friend, but it is for X's use. Benami. You buy some property in uncle, auntie, niece, nephew, something name with your funds for your benefit. Immediate or future, direct or indirect. Benami. IPOs, I give you an example. Benami, unless the demat accounts are joined. Now, please don't give me an answer, friends, that, but everybody is doing it, so what? I can understand that everybody is doing it, friends, but I'm telling you the legal position the way I interpret it. In a search, I gave you this example also, that the lady is not able to remember. It's possible. But friends, over here, I will say that just because there is a memory lapse does not mean it is a Benami transaction. This can be a genuine transaction. Maybe the lady doesn't remember all of this, maybe. But warning sign is there. Take enough of precaution for this. Now, here it is a lady who will be a senior ascendant in the family. So I wouldn't say it's a strong case of a Benami, but still. Okay. X issues a check directly from his account to buy something in the name of Y. Will it be Benami? No, friends. You just don't give an answer whether it is Benami based on this information. Go to 29A every time. Who's providing the consideration and whose name it is taken. That's two part, but the third part is important. It is for my benefit. Immediate or future, direct, indirect. That has to be satisfied. Only then it will be Benami or it will not be Benami with the 4 exclusions. Intention plays a very, very critical role in Benami. Very critical. This is a punitive law. Intention is playing a role. For example, bank is issuing a check directly to the house owner. So bank is providing a check. The house is in somebody else's name. That means it is Benami? No, because the third part is not satisfied. It is not meant for the bank. Okay, there may be a delinquency or an NP and then the bank takes over. That's a different issue. But the intention at the time of giving the housing loan was not that the house should be for the benefit of the bank. So taking a bank loan and doing business, sorry, purchasing assets with loan from NBFC, etc., doesn't come under Benami, friends. Now you have some idea of Benami, 29A, 4 exclusions, B, C, D, and an explanation also. This is the structure of the act. The procedures are, there are authorities in Benami. You have an initiating officer, IO. He is normally a DCIT level. Above him, you have an approving authority with the JCIT level. Above him, you have an adjudicating authority. The adjudicating authority is the authority who is administering or regulating SAFEMA, Smuggling and Foreign Exchange Manipulators Act. There was an act. You know about COFEPOSA Act, COFEPOSA. So SAFEMA is an act. So there was an adjudicating appropriate authority in SAFEMA. Now that authority has been given the work of Benami also. So we have SAFEMA adjudicating authority in Mumbai, Delhi, Calcutta, Chennai. All these 4 metros. And so after the initiating officer does his work, the file is transferred to the adjudicating authority. The adjudicating authority will do their work, which I'll tell you, and then the file goes to the, you may file an appeal before the tribunal. There's also somebody known as an administrator, who's a TRO, just the authorities. And all these authorities, IO, approving authority, adjudicating authority, administrator, the TRO, they all have got a powers like a court. This is typical to a 131. They can, discover, ask for issues, enforce attendance, examine on oath, call for books of accounts, etc., issuing commissions. Friends, section 131 also has issuing commission. What do you mean by issuing commissions? Receiving evidences on affidavits, friends. In Income Tax Act, my suggestion, and in Benami also, very often when you're filing evidences, file affidavits also of evidences. Affidavits, statement on oath, affidavit. So what do you mention? A statement on oath, it carries a lot of value. Issuing commission basically means sometimes, you can't get the person to the office of the IO or the ITO. So you can tell the ITO, issue a commissioner, let him go over there and record a statement. That is issuing commissions. That is possible and that can be done. Sometimes for old people or it's difficult to bring someone. You can request that please issue a commission. Means issuing a commissioner. So these authorities, IO and adjudicating authority and all that, they can call for information, enforce attendance, reporting entities. These reporting entities and intermediaries are from the PMLA. And the Benami department can take the help of the police officers also for calling for any information. They can do a general fishing inquiry. I'm repeating, virtually general fishing inquiry. So they can ask any government of authority to furnish them any information, whether it is relevant or irrelevant in this act. They can ask for that. And they also have powers of impounding books of accounts, and the books of accounts can be retained till 3 months. And thereafter also, there is further impound culmination of the entire process, and copies can be given to the person whose books of accounts, etc., have been impounded. Not that much important, but still I'm just telling you for all this technical material. And after obtaining approval from the approving authority, the AO has got the power to conduct a general inquiry, investigation regarding any person, any place, any document, any property in respect of any matters relevant under. So if somebody gives an information to the Benami department, okay, is aadmi ke paas bahut Benami property which is in the name of his servant. So before taking action, IO may do inquiry. Section 23, he may do certain inquiries over there. And then, like in income tax, the notice is 143 subsection 2, means the scrutiny is triggered. That notice in Benami is 24(1). Now starts the actual Benami process. So the initiating officer, IO, on the basis of material in his possession has reason to believe that any person is a benamidar of a property, he may, after recording reasons, he has to record reasons, 148. Record reasons, serve a show cause notice to the person and tell him that you're holding this property or whatever. Why should you not be treated as benamidar? And he can also serve a copy of the notice to the beneficial owner also. And the moment he serves the notice, generally we have observed, generally the initiating officer attaches that property. And he will keep it attached for 90 days from the end of the month in which the notice is issued. Or IO may not attach it immediately. He may conduct the investigation and at the end of 90 days, he may attach the property or may not attach the property. But generally, we find that the moment a 24 subsection 1 notice comes, the concerned property over there, whether movable, immovable, bank fixed deposit, shares, car, flat, residential house building will get attached. Attached, not physical possession. And then the benamidar will give his explanation in the period of 90 days and the beneficial owner will give his explanation and all that starts. So the inquiry, this is very nice. The inquiry is 90 days, no extension, nothing doing, culminate the inquiry within 90 days and on the completion of 90th day, the IO within 15 days will send his so-called provisional attachment order or continuation of the provisional attachment order with whatever evidences we have, whatever we have submitted before the IO, all his findings, he makes it and he sends it to the adjudicating authority, which is in Mumbai, Delhi, Kolkata, Chennai. The next level, it's not an appellate authority, it is a superior authority, that's all. Now comes to the adjudicating authority. So the IO's work is over and the IO will be supervised by the approving authority, JCIT. Now, the ball comes from the court of the adjudicating authority. As a chartered accountant, you can represent there also. The AA has 1 year time. They will examine the same thing in detail. If you feel IO has done injustice, please argue your case before the AA. If you feel the IO has not done this, not done that, done this, that, natural justice, no cross-examination, blah, 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 whatever you want to say, argue that before the adjudicating authority and then the adjudicating authority is 1 year, time bound 1 year, and then the adjudicating authority passes an order under 26 subsection 3, either treating it as Benami property, partly Benami property, or releasing it, that no, it is not Benami property. Sometimes the property is not referred by the IO, that also the adjudicating authority can attach later on during the course of the proceedings, and they can release a property also. So they may continue with the attachment, confirm the attachment, sorry, not continue, confirm the attachment, or release those that particular property. And they can accordingly pass orders against the order of the adjudicating authority. The first appeal is before the Benami tribunal. Now this is only at Delhi. Now after this procedure of passing the order, the adjudicating authority can confiscate the property, physical confiscation. Yes, that is there in the law. It is not happening now, but it is there in the law. A physical confiscation procedure can take place, and then that confiscated property goes to the TRO within a defined time period. Now, because of this COVID thing, there were a lot of extensions because the adjudicating authority was not working in Delhi, and neither were the IO working. So there were a lot of extensions in the earlier slide. Let's not get into that. That's history now. Now, friends, critical thing. I'm purchasing a property. I don't know it's a Benami property. It's not a Benami property. Honestly, I'm paying consideration and I bought the property. And tomorrow something happens. Will I lose the property? Answer to the best of my understanding is not so. But before me purchasing the property, a section 24(1) notice was already issued on the property. And even in ignorance, if I buy such a property, then I will have to face the music. Due diligence has to be done. I know this may sound very scary and difficult, but that is the way it is. That is the way it is. That is the way it happens in PMLA also. So if honestly he has bought before section 24(1), then yes, he has bought for valid consideration. But after 24(1) notice, no way, not allowed at all. And of course, you can't do a transaction to defeat the provisions of PBPT by selling of that property. No way, that's not allowed. And if it is caught, the transactions can be reversed, friends. So this is about 24 and 57. So right of any third person can be protected also, and his right can be defeated also. Now the appellate tribunal They hear appeals against the order of the authority, IO approve anyone, and appeals of the adjudicating authority go to the tribunal, which is at Delhi. They are not governed by the CPC but rules on natural justice, just like our ITAT. They also take evidence on affidavits, and within 45 days you have to file an appeal. It has judicial member. And friends, it's at Loknayak Bhavan. Just for information, currently the chairman over there is Justice Munishwar Nath Bhandari. Members are Mr. G.C. Mishra, who comes from the Central Board of Indirect Taxes, and Mr. V. Anand Rajan. He's an ex, if I'm right, Chief Commissioner of Income Tax, and Mr. Balish Kumar. These honorable members are on the bench at the Appellate Tribunal at Delhi. They hear your appeals of Benami. Whatever I'm arguing and presenting before you all are heard by these honorable authorities. There is something like a rectification of mistake also. Any rectification of mistake apparent on the face of the record, only that is corrected, like our 154. Simple. Chartered accountants and all of us can appear before the tribunal and before IO and adjudicating authority. After the tribunal, only question of law will travel to the High Court. The jurisdiction will be the place where the IO has initiated the Benami proceedings. So the IO Mumbai has initiated proceedings. So from the Delhi tribunal, my jurisdiction will be Mumbai High Court, and I have to file an appeal before the Bombay High Court. But question of fact will not be entertained like income tax, only question of law. Now, friends, this was one segment. IO, 24/1 notice, adjudicating authority, tribunal. And immediately, normally, I should not say immediately, normally, after the adjudicating authority's order, the IO may file a criminal prosecution before the sessions court, like PMLA. And then you have to go and seek bail. Though you may be at the tribunal, you can say that the quantum issue is not got over, so why should prosecution start? But I don't know how many of you all must have seen that in income tax also, that the CRT appeal is pending, or the ITAT quantum issues are pending, and prosecution has started over here also. So in Benami also, the second segment of prosecution can start, which needs permission from the PCIT or the PDIT. Of course, prosecution is only if Benami transactions to defeat any law, avoid any payment of statutory dues or payment to creditors and things like that. But prosecution is possible, and I'm myself facing prosecution in a few cases, though my matter is at the Benami tribunal. Anybody who's called in the IO proceedings or in the adjudicating authority proceedings, if he gives false information or false documentation, then there is fine and imprisonment also. Anyway, let's ignore all of this. Prosecution will follow CRPC, Criminal Procedure Code. Now, in a Benami proceeding, no court, no civil court will have jurisdiction. Yes, you can file a writ in the High Court, but that is in exceptional circumstances. Otherwise, the city civil courts means the lower courts, they cannot interfere, they cannot give any kind of injunctions, etc. And the central government, now I'd give an example. Remember in fiduciary, I take an example of a trust. Now, trust can also have Benami properties. It is possible. Sometimes people misuse trusts also. So the central government in Section 58, they have an option. They have I should say, a section in their hands. They can exempt any property of a trust from the operation of the Benami Act. Otherwise, trusts are also covered by Benami Act. But if they want, the government wants, they can exempt any property from the application of the PBPT Act. That's it. Okay. So it is an addition and not in derogation to any other laws. So other laws can also work simultaneously. Now, friends, from here onwards, this is the last parts. We have certain judgments. Now, in Benami, we have had certain judgments, but they have been more academic in nature, and we rely them on their, not ratio descendi, on their obiter dicta part. So basically, this was the first Supreme Court. This was one of the Supreme Court judgments of 1957 to explain something on Benami. I will not go deep into it. This Bhim Singh Khan Singh case is a celebrated judgment to explain what kind of Benami transactions are there. What is a Benami transaction? What is a sham transaction? Friends, I just need to tell you, a Benami is where I purchase something in someone else's name with my money for my benefit. That's Benami. A sham transaction is where somebody sells something to me. The intention is not to sell, but only on paper we are showing something. Maybe the consideration also is not passed. It's possible. It's a sham transaction. Sham is different and Benami is different. So in Bhim Singh Khan Singh case, they analyzed this thing and they also explained the nitty-gritties of, what are the ingredients of a Benami transaction. This was also referred in the Valiamal case, the 6 circumstances which can be taken as a guide to determine the nature of transaction, the source from which the money came, nature and possession of the property after the purchase. वो car किसके पास है after the purchase? Motive for giving the transaction. Motive means the car should be used for me. Position of the parties and relationship between the claimant and the benamidar. What is the relationship? Custody of title deeds. Now that car is in his garage, but the title deeds are with me. I am only looking after the maintenance, etc. Indirectly, it gives an impression that it is meant for me. Conduct of the parties. So this is critical. Mahalingappa case also Supreme Court. Again, what are the circumstantial issues which should be seen in arriving whether it is a Benami transaction or not? So this is good as far as guiding principles are concerned. We have got some income tax cases also on Benami, means how Benami played a role in income tax. Like, typically partnership firms and somebody being a partner and the person was partner only on name purpose and not actually being a partner. So these kind of cases were analyzed, but of course, all that I can say is that these cases have been prior to 25/10/2016, so they have not been hit with the Benami Act now after the Supreme Court judgment. Same one over here also, there was this partnership firm which is controlled by one T, but T was not a partner, somebody else was there a partner, maybe a servant and this and that. So in these kind of situations, the ITO came to the conclusion that it is Benami, all these only name lenders, and name lender is a Benami under 2 subsection 10, 9 or 10 of the Benami Act. So that's why the Benami issues were invoked over there. Similarly over here also. In ladies' cases also, they have sometimes, analyzed cases where a lady becomes a partner in a firm and she's not having any technical background and you just make her a partner in a firm. Of course, you can argue because she's contributed capital or made a proprietor of a firm. Now making a proprietor, but actually somebody else is running the shots, is calling the shots. So a typical Benami kind of a situation is developing there also. It's like with my money, I'm running a proprietary firm in the name of my wife. Banking transactions rights given to me. I'm only taking the call and the profits are meant for me, for my purpose. Now, yes, an exception is there. I'm not saying no. But if instead of a wife, I put cousin brother or chacha, mama, kaka, then one has to be very, very careful. The Benami Act can be activated. Same over here also. All these slides were basically similar such cases. So in 2016, when November they came up with this, and if you remember, there was a voluntary disclosure scheme in 2016, July, August. There they gave an exit for all Benami transactions. If you would have seen the details of the scheme. Now in hindsight, when we see things, अब पता चलता है कि okay, 1st November को वो लाए, 8 November को demonetization लाए, and VDS came in June, July 2016, where they permitted if you want to exit from Benami properties, you can exit. So that was permitted. Friends, Benami transactions are typically linked with 69A or even 68 and 115 BBE, because if they feel that the person who's the owner, means ostensible owner, means the Benamidar owner, only the name lender, and the real owner is someone else, then besides the protective assessment, they can also do a PBBT invocation. So all cases where fictitious expenses are there, a person gives cash to somebody and gives a check to somebody as commission and the cash comes back, or fictitious loans or fictitious gifts or fictitious sales or fictitious purchases. The Benami tribunal is flooded with cases of fictitious purchases and sales, especially during demonetization period and early 2017 period. Because name lenders were there, they admitted before the department that I've taken a commission and I've done this work. They invoked these provisions of PBTT 29A or not traceable and things like that, and fake share premium transactions also. Friends, Kolkata High Court in Ganpati Dealcom said that retrospective application is not applicable. The Supreme Court stayed this, and then comes the judgment of Supreme Court, which I told you in the beginning, dated 23rd of August, where they very clearly mentioned, and so now you can just sit back and relax, that Benami transactions prior to 25/10, it's not 1/11/2016, it is 25/10/2016. Even I found it strange. But prior to 25/10/2016, the authorities, the IO, adjudicating authority, nobody can initiate or continue. Where it is initiated, they will also abate. Criminal prosecution or confiscation proceeding, nothing. So all these have lapsed and everybody is free from that reign of terror. These are certain observations of the Supreme Court. They said that the question for us is whether the 2016 Act is retroactive or prospective. Friends, there are 3 words: retrospective, prospective, and there is a third word, retroactive. Retroactive, like RERA is a retroactive law. Something is retrospectively, something will be prospectively, and something is retroactive. This was also examined over here. Is 2016 Act a retroactive or a prospective act? Is mens rea required under Section 53? Yes. Then civil consequence of Section 4. Section 4 was what in PBPT Act? The real owner cannot file a suit to recover the property from the Benamidar. So yes, that still remains. And there was no question of retroactive application of the Benami Act. No question of retroactive. Retrospective nahi, retroactive bhi nahi of the 2016 Act. And then the decision was given in para 18. The section 3 subsection 2 means all Benami transactions prior to 25/10/2016 unconstitutional, violative of Article 21, which I told you in the beginning. An important observation: 2016 amendment is not procedural. आपने 9 sections का 72 sections कर दिया. Its substantive provisions have been changed over there, and it is punitive in nature. It can be applied prospectively, not retrospectively. So that part of the story is all over. We have a Kolkata High Court judgment also on this particular subject. So Kolkata High Court, this judgment, why, of course, after Ganpati, this may not be of much relevance, but still, if a division bench has passed a judgment in the same court, the single bench will also pass a judgment similar to the division bench. If the SLP is only staying the judgment, there's a difference between staying of an order and quashing of an order. There's a difference over there. If an order has just been stayed, friends, just stayed. So the original order is there, but it is stayed. If it is coming from a high court, so that high court will continue passing such orders because the main order is only stayed. But if the order is quashed by the Supreme Court, then the subsequent judgments of the High Court will not follow that order because it has been quashed. What I want to say is, academically, there is a difference between staying of an order and quashing of an order. In this, we found only staying of orders. This was an initial case of Rajasthan High Court Niharika. This also said retrospective not allowed. Now it is of no relevance because this thing has lost its importance after the Ganpati deal problem. Bombay High Court had a case of Joseph Isharat Raj. This was not a Benami case. Lekin here the person wanted to take benefit of Benami. Joseph ki daughter thi Rosie. Rosie was a stepdaughter of Joseph, and Joseph bought some property in the name of stepdaughter, and later on claimed that that stepdaughter, you can buy a property in the name of the child. Child includes the stepchild also, and so that is a property of the person who's contributing, and there is no Benami transaction. They tried to invoke these provisions recently over here in this case, but of course it was not a PPPT case, and Bombay High Court also here said that retrospective application does not fight. But for academic reasons, this is a good how people use the Benami provision sometimes for even acquiring property or to stop property being given to the real owner. Section 4, Benamidar need not give the property back to the real owner. And then Chhattisgarh High Court was the only judgment which said no, the Benami Act is applicable retroactively. They gave a very good logic for this, friends. This logic is just worth understanding. They said that even transactions which have taken place prior to 1/11/2016 will be covered. Of course, now it is not applicable after the Ganpati case. Because what was the logic, that a Benami is a continuing offense. So transaction took place prior to November 2016, but that property is still there in the hands of the Benamidar. So it is still a Benami transaction and it is still a Benami property. So it is a continuous offense which is happening or taking place. And hence, continuity, it has reached till 1/11/2016. That is the day when the legislation came into action. That is the day when the legislation came into action. So it is a retroactive process and hence it should be applied. This was their logic. I've given an example. Supposing by legislation, it is prohibited to hold anything like some certain foreign made goods. It is prohibited to hold. Now you can't hold a prohibition from a back date. Retrospective application of punitive acts are not allowed. But as on the date of the act, you're holding that foreign goods and it is not allowed by law. Now what? So there should be a way in which the people are allowed to sell off those foreign goods and come back into the mainstream of the law. Somewhat this kind of an inference was drawn by the Chhattisgarh High Court, but let's not get into that because Ganpati has now terminated all these judgments. We have this Lilavati judgment also, friends, again on, intention, both these cases. It's more of academic reading, so maybe I can skip a little bit of this because all this will be helpful to all of you all. I'm just running against time. I'm so sorry for that. Well. Yes, these are certain observations in the Leelavati case. Why I've taken it over here, it is important. Now, friends, there is one thing, and even I had to suffer because of that. Very often in income tax, we ask for cross-examination. In Benami also, we ask for cross-examination. Somebody is making a statement against me. I want to cross-examine him. Cross-examination can be legitimate. But ideally, cross-examination should be done by the parties, or it can be done by a professional in the presence of my client. I repeat, cross-examination can be done by the professional in the presence of the client. So that can be a principle of natural justice, which was there in this particular case of Ramneek Singh. Okay, there were cases where this is the Rajasthan. Okay, this was the Rajasthan High Court of Kalyan Buildmart. Actually, in this case, what happened? Somebody wanted to buy agricultural land. The farmers are not ready to sell to this person. So this person created a company, put some directors in the company, gave them the money and told them, now you buy the agricultural land. Farmers sold it to him. Thereafter, he took over the share capital of that company. So he became the owner of the company. It was round tripping. ITO said, this is Benami. So the question came, okay, where is the question of Benami? Companies provided the consideration. Company can borrow from anyone, no? Company can take a loan, no? Company can have share capital. The shareholders can borrow money and put share capital. So the company is an entity under the law. The company got the money. The company paid for the agricultural land and bought the agricultural land in its name for its own purpose. Where is the agricultural land held in the name of the Benamidar? Is the company not traceable? It is there on ROC. Source of consideration, yes, from the shareholders, they contributed money and they paid. How did the shareholders get? How did that fellow get? No, the company had the money. Known sources, not known sources of income. The company had the money. The company acquired land in its name for its own benefit. Where is the question of 29A being invoked, or 29B, C, D, whatever? Where is it being invoked? Ideally, if there's a Benami transaction, ideally, look at the observation of Rajasthan High Court. Within 3 months, it should be reported and action should be taken. This for the first time we are finding something like this coming over here. Well, this was also by the Rajasthan. Okay, this is the same case law which I was telling you all. The property bought in someone else's name. Friends, standard operating procedures have been prescribed by the Benami department, and sometimes the Benami property is in Delhi, Benami Dar is in Mumbai, and Benami real owner is in Calcutta. Which Benami unit is going to initiate the action? Now, I'm a little surprised to tell you, but here the department has given this SOP. They're going to follow something known as fastest finger first. Means the Benami unit of Delhi, the Benami unit of Mumbai, or the Benami unit of Calcutta. Who initiates the first 24 subsection 1 notice? The proceedings will start from that Benami unit. Yes, it may sound funny. These are the replies about, Benami transactions being hit with mosque, Gurdwara, temple. Friends, with all due respect, sometimes religious places are misused for Benami because there is something known as a donation box in religious institutions where the person who contributes money is anonymous donation, and for a religious institution anonymous donation is not hit with direct taxes like 30%. Of course you have to spend money according to section 11, and so the religious institutions buys lavish cars and lavish bungalows and all that. I'm talking about the mischief making ones. It can be a case of Benami. So people were a little afraid, and that's why on the floor of parliament certain answers were given. There's a Benami transaction information reward system. So if anybody is giving information of Benami, they can get rewards also. Subject is new. Subject has great scope for practice, friends. And chartered accountants are practicing, travel to Delhi, but I'm not finding a lot of chartered accountants practice in this. Yes, we have a lot of lawyers, my friends from Delhi who are practicing, and from other places. But unfortunately, and I don't know why, there are not many chartered accountants practicing, and we are reasonably good. We are pretty good as far as having a trail of money and all these aspects of 29A, BCD. So I feel this is a great area of practice. We all should come together and intensify our efforts in this particular field so as to take it to greater heights with adding more and more knowledge to the subject. I can only, there are a lot of questions over here. Can I take up some questions in the limited time I have? Mr. Sudhakaran Kotappan, you have mentioned the risk danger of POI being getting notarized instead of POI being registered with us. Is it applicable to POI made in all states of India? Yes. You want to use a POI especially for transactions of properties, etc. You have to get it registered. Simple as that. Especially after the Suraj Labs judgment of 2012 Supreme Court. Notarizing is not going to help you. It has to be registered. And if you register it, you have to pay the stamp duty also. Mr. Dasarathi Vijay Raghavan, many properties held in private limited companies of a group wherein employees are directors, can they treat it with Benami? No, 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 no. To answer a question whether something is Benami or not Benami, touch everything on the cornerstone of 29A, 29B, 29C, 29D. Rub it, sort of test it on that. Rub it hard on those sections and see, does it qualify over there? 29A and the 3 parts or the 4 exclusions, and then only. Just because properties are held in private limited company of a group where employees are the directors doesn't mean it is Benami. The Kalyan Hart case, the Kalyan Mart case of Rajasthan High Court is reasonably similar to what you're asking me, Mr. Dasarath Vijay Raghavan. Ashok Malia, please share PPT. Yes, of course, I will share it. Knowledge is everybody's property, friends. Sir, retiring husband makes deposit of his retirement. Raghavan P. Retiring husband makes deposits of his retirement benefit in the name of his wife. Will this trigger 29A? Prima facie and so much information? No, it will not trigger. And the wife will be considered Benamidar? No. Husband can always give money to his wife. Okay, there'll be clubbing. That's another thing, clubbing of income. Under income tax, such deposits is usually tax in the hands of problem. Okay, so it doesn't mean Benami will be attracted just because I give 1 to 5 10 crores to my wife and she makes an FD in her name. No, not on only on so much information. And there are exclusions also. In the previous slide regarding power of attorney, there's a sentence: contract is registered and mandatory toward Benami. Is power of attorney is available? Is power of attorney is available? Is it sufficient, or any other agreement for sale to be registered? Normally, if you're doing a transaction through a power of attorney, the power of attorney should be registered. But if it is being done through any other agreement, and whatever may be that intermediary agreement, ideally should be registered. But in real world, we find that people use power of attorney extensively for doing incomplete transactions in properties, especially they want to switch out of the property, make some profit and switch out. Sir, I don't understand the final word on female descendants. Nikita Agrawal. Nikita Agrawal, my take on female descendants is that a line of ascendancy-descendancy can be established as far as females are also concerned. But yes, it requires a lot more research on this particular subject. Property transferred at nominal value can be covered in Benami. Hitesh Kumar Jain. Hitesh, the issue in Benami property is not so much about the value of the property, but rather the intention that, I buy the property with my money in someone else's name for my benefit. That may involve under overvaluation. Many things can happen over there. So that may trigger more of that may trigger a Benami aspect. But to determine whether it is Benami or non-Benami, again, the benchmark is 29A, B, C, D, and those clauses which we read over there. That is important. Just because nominal value pay hai, market value pay nahi, it is not on the stamp duty value. For that, income tax has 50C and all that. But Benami will not come into action always. Benami Act, who's this? Hitesh. Benami Act applicable only to money generated from predicate offense? No. Predicate offenses concerning PMLA. Benami may be even regarding genuine, legitimate accounted money. That can also have a Benami implication. I've got genuine, legitimate accounted money, and still I can indulge in Benami transactions. I was just trying to show the interplay. Very often in PMLA, they also do Benami. But to say that Benami is only generated from predicate offenses would be not right. Property allotted, anonymous. Property allotted by housing board in each state government. I am so sorry. This is something which is coming pretty lengthy. Sale value registered, but till now property name the chairman is not registered in name, but enjoyed by allottee where the transaction comes in. Oh, that means some property allotted by state housing board. It is the name of an individual. Sale value has been paid. Property is still in the name of the chairman of the housing board. So was chairman the person in whose name it was allotted? I wouldn't know. Or is chairman who's the person who's buying the property? Nevertheless, if an incomplete transaction is being done under section 53A, the transaction should be stamp duty and registered. Paul Pratap Karan, if a seller is not able to do a proper due diligence on remote property, what precaution he should be taken? The precaution can be newspaper notice and a casual checkup from the Benami property unit in your jurisdiction area. Can brother gift money by bank transaction to his sibling? Yes, of course he can. Is it covered by Benami? No, 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 no. Just a simple gift or a loan and all that is not covered by Benami. Friends, don't carry an impression that, you know, this gifting between family members or even outsiders or loans and all that is Benami. No, no, no. I'm again and again stressing the point. To answer whether something is Benami or not Benami, we have to, the cornerstone of test is 29A, B, C, and D. If it satisfies those conditions, it is Benami. If it doesn't satisfy, it is not Benami. That's all that I can find over here, friends. Nothing else. Do I have anybody from SIRC online? Is there anybody from
Hello?
SIRC?
Hello, can you
Yeah,
hear
yeah.
me, sir?
Yeah, yeah.
Hello?
Yes, I can hear you loud and
Yeah.
clear.
Okay, sir. So thank you very much. So on behalf of SIRC of ICAI, we thank you for sharing your knowledge and clarifying all our doubts. So once again, from bottom of our heart, so we thank you very much for sharing your knowledge and spending our time with us. So thank you very much.
Thank you so much.